Welcome everyone to today's episode of the Rogue Thoughts podcast. Today we have a esteemed Professor Michael Smith with us. Michael Smith graduated from UCLA Law, where he was on law review and moot court. He went on to work for the Orange County District Attorney's Office and then became a litigator in private practice. He's now a distinguished professor who has published numerous articles and has spoken at a lot of events, mainly the Constitutional Law Colloquium. Thank you for being with us today.
Happy to be here. Thank you for having me.
Thank you. So, you've been in the legal field for a while, and I'm sure you have some thoughts on it. What do you think is the biggest problem it's seeing right now? And if you could, how would you fix it?
I mean, that's a big question. And biggest might be impossible for me to answer, but there's certainly some big problems that come to mind. I think one in particular that sort of contains multitudes on its own is this notion of kind of access to justice. I think that has and remains a problem across a wide range of legal fields. The inability of people to effectively get representation and have their interests heard and recognized in courts and in other legal settings, including administrative settings. These are very specific worlds governed by very specific rules. Lawyers and those who know the system can effectively guide people through and help them come through relatively unscathed. And I think that there is just a general lack of an ability to get affordable legal representation, competent legal representation, and that lack in the civil field, certainly in the criminal field, where I've had both professional and academic experience. I think those are fairly pronounced problems there. How would we fix it? I think that there's a lot of, Band-Aids and ways of potentially papering over the problem that might make things a little bit better. But I think to fix it or to really even address it in a meaningful way, I think there just needs to be more resources. I think there needs to be more funding, more support for legal aid and other organizations, government organizations like public defenders who provide criminal service. There just needs to be more resources and priority given to them by policymakers. And I worry that either those policies aren't popular and won't get passed, or there may be solutions that I think will not really solve or meaningfully address the underlying problems, such as, and I bet we'll get into this later, enhancing workload or representation ability through, AI or measures like that. I think while that could maybe make some difference, the underlying problem still remains.
You mentioned resources. When you say resources, do you mean mainly funding and money, or are there any other things specifically?
Funding and money at the basis, which then leads to a lot of other things. So take a public defender's office, for example. A lot of them are underfunded, and that underfunding means that they have staffing shortages, both at maybe most obviously at the attorney level, not enough attorneys to handle cases, very substantial caseloads, which leads to an inability to handle everything on their plates. That in turn leads to a lot of attrition, which leads to an experience deficit in many offices. But there's also, staffing shortages that result from the funding shortages at the administrative level, at the investigator level. There's a lot of other people that need to do work, and that lack of funding at base just sort of leads to those staffing failures at all levels, which in turn lead to other problems. So in the end, I think funding is probably one of the most straightforward ways to try to solve and to try to address some of those shortcomings. Not the only way, I suspect. You certainly have other more structural inequalities from, say, rural or urban environments, with folks in more rural environments often having shortcomings where you need to bring people in who might not otherwise be there. But that would be, I think, one example of a type of resource to bring to bear on the problem.
You mentioned funding and overworked public defenders. Do you think that them being overworked kind of hampers their ability to be effective counsel, or do you think that's something they would bring up and say, or can they even bring that up and say, hey, I'm being overworked, we need to get this case passed along to someone else, or how does that work?
I think it does affect public defenders and their ability to represent people. I have, as a former district attorney, I have worked, with and against public defenders in the past, and my experience was they managed to get by and even thrive in an incredibly high caseload, high pressure environment. They do a great job, but I think they could do a better job. And I think they would probably agree they could do an even more effective job, trace down more leads, develop defenses, make more arguments, have a greater depth of research when they do a law or motion situation, if they had that greater level of work. So, and in terms of, can they say declare a conflict or declare they're not able to do something? I mean, I suppose that option is sometimes available, but often practically it's not. They could declare that they're not able to do something, but then who else is there to handle it? There might be nobody if we're in a sufficiently rural environment where there really is no one else there to pick up the slack. And there may be other attorneys, perhaps panel counsel or appointed counsel, but there may be genuine concerns about whether those people are sufficiently equipped, have the right level of expertise, especially in maybe more specialized defense situations, to come in and provide, genuinely quality representation. And so a public defender who's considering, maybe I should say that I can't do this, for the good of their clients, is probably going to be taking that into account as well, and may think, for the sake of my client and getting them the best representation, I should stay on, even though in a perfect world, it would be good for a different public defender or an additional public defender to take on some of these cases and to pick up that load.
You said worked with and sometimes worked against public defenders as a DA. Did you find it was more one-sided, or that it all depended on who the lawyer was at the time on that case?
I mean, everyone has their own sort of personalities, both at the DA's office and at public defenders' offices and private defenders' offices. I mean, well, and in the litigation world as well. I think that there were definitely some folks who I had better, more cordial relationships with. Some were a little bit more aggressive or standoffish, but in the end, we were all there, understanding that we were part of an adversarial system and were there to do our jobs to the best of our abilities. I understood that they were there to represent their client and to give their client every advantage and to make every objection and to raise every defense they could. As the DA, I talk about working against them, and certainly sometimes that would happen. You go to a trial, you're arguing your side of the case, but sometimes you're working with them as well. They raise a defense. They bring a motion, or they say, look, before we bring the motion to dismiss or the motion to suppress, here's what I'm seeing and here's the problem. Do you have an answer to this? And sometimes if they raise that, it hadn't come up, it raises a genuine issue of procedure, and I, as the prosecutor, thinking, yeah, that's going to be it. That's going to do it. At that point, you work with them to dismiss the case. If it turns out that the fact demonstrates that the person did not do the crime, you dismiss the case because they're not actually guilty. And I think that as a prosecutor, that would happen on multiple occasions, and prosecutors and people who want to be prosecutors should realize that. Your job is not there to win. Your job is to do justice and to find truth as the prosecutor. And sometimes that will mean prosecuting the person through an adversarial trial, motion, or what have you. But other times, and all the time, that means you need to be cognizant of what the other side is arguing. And if they have demonstrated a genuine problem with the case, you should accommodate and be willing to go with and dismiss if necessary. Should that problem be real, and should it really, warrant dropping or altering of the charges?
You mentioned kind of you would discuss this before the motion or before a trial. Were there any times where you were blindsided completely, and if so, how did you react to that?
Oh, I'm sure that happened at trial. At trial, it happened, a number of times, I'm sure. I did a number of trials, I think 9 jury trials overall, during my year at the district attorney's office, all of them misdemeanors, most of them DUIs and things like that. And there were instances where I was blindsided. I wouldn't say it was the defense that really blindsided me. The blindsiding that I experienced was a witness who goes up and says something that you don't expect. And a number of times we would have, let's say, an eyewitness. I remember there was one case where it was a resisting arrest and assault on a police officer case. It involved basically a guy running from the police and throwing stuff at the officers. And an eyewitness came up and testified and was much more dramatic than I think anyone expected about sort of the takedowns. The officer got him and whammed him to the ground, and I heard his head hit the pavement, and I was like, oh my goodness. The police, the police reports are generally pretty much like, we caught up to and apprehended the suspect. And you have this witness coming forward and adding a lot of color and a lot of detail that you may not have necessarily realized was going to be coming, even if you've had a chance to talk to the officers ahead of time. And so that can be surprising. There can be a temptation to sort of, should I do something about this? I found that in situations like that, unless it's, genuinely significant or changes the equation, a lot of the time you just roll with it. And if you're surprised, as long as you don't look surprised, it may well not register with the jury, and you can simply move on with the case as planned.
Did you find ever that those arresting officers were combative towards you in a way where like we did the job, we did what we were supposed to do, but you're not getting it done because you didn't get them fully prosecuted, I guess?
I can't think of an instance where I really butted heads all that much with the officers, either in the trial and I would work with them too, like in motions to suppress, we'd have to bring them in a lot of the time for those hearings. And I would have calls frequently with officers at the charging stage where I would maybe have questions about a police report, missing details and things like that. And by and large, my interactions were all professional, all cordial, with the officers understanding that, they have their job to do of going out, enforcing the law to the best of their ability. We, on the other hand, are a second pair of eyes on the case, and we may spot things with our detached perspective and, legal expertise that might have been missed initially. And generally, when those sort of disputes came up, the officers, in my experience, were fairly understanding. I guess the most sort of tension I would usually have would just be kind of the scheduling. Honestly, there was a month where I was on the trial desk, and my job was to have every case set for jury trial ready to go so that another DA could just walk in, take the file, and head off to a courtroom and start trying it immediately. I had to do all the prep to get the case to that point. And the toughest part of that job, or there were lots of tough parts about that job, but one of the ones that stands out in memory the most was just coordinating everyone that needed to be there. The witnesses, the officers, wrestling with everyone's schedule. And, sometimes you'd have an officer who's leaving this day or that day, and you'd have to get them in this day only for the trial. And sometimes tensions could arise over, availability, calling them down at an inconvenient time. But even when I could tell that this wasn't the best situation for them, they'd been on a long shift or something like that, all of the officers that I really remember working with, nevertheless, were incredibly professional about it. And they would roll with the punches, even though I knew that it was rough some of the time.
Just for our audience so they have an idea, how you did both civil and criminal, how often do
Yes.
those cases go to trial actually?
Good question. And in my experience, it varied tremendously from criminal to civil. I'd say in criminal, the vast majority of the cases would settle through a plea negotiation, maybe sometimes be dismissed, occasionally also be dismissed if there was a successful motion to dismiss or something like that. I would say maybe 5 to 10%. This is, again, speaking specifically from the misdemeanor criminal level from my experience. 5 to 10%-ish, I felt like would ultimately go out to trial, probably closer to 5, maybe even less than 5. We had a very high volume of cases. We had a fair number of trials, but a lot of underlying cases. I would say maybe 5. Civil, did that for much longer. I was a civil litigator for about 7 years compared to the 1 year that I was at the DA's office. Had a few arbitrations. Got real close to a jury trial or to a bench trial in one, I think to a jury trial in another, but those were also settled on the eve. I never had a jury trial in my 7 years of civil litigation. Other colleagues of mine did. It was kind of luck of the draw of the case you were on. And actually, I did have one case that was going to trial in Delaware. I was helping from afar from a different time zone. Lovely. Love working on Pacific time on an Eastern time trial. So I guess there was a trial that happened there that I was technically on remotely, but otherwise much higher rate of settling, which I think in a lot of civil litigation is the case. Although again, you have your exceptions. One of the partners I worked for, he had cut his teeth at trial and gotten a ton of experience as a very new attorney, taking on just a bunch of unlawful detainer cases. He told me that he wanted trial experience, so he would, I think, sometimes even just volunteer, go in, represent people pro bono in these eviction cases. And, they were short, they were uncomplicated, but he was in the court making the arguments, opening, closing documents, little mini trials. That was how he was able to do it. And those tended to go at a much higher rate than other lawsuits that you would see.
What were the biggest things you learned from prepping and almost getting all the way through trial?
At the DA's office, the rule was if you prep a case, it's not actually going to go to trial. It'll settle immediately. The general rule was like, you're jinxing yourself by preparing a case. It actually won't go to trial if that's the case. But what did I mean, the importance of preparation, just the number of steps that go into a case and that come to bear on the end, and not even at trial, but in a civil case, for instance, you have the pleading documents, you have your basic written discovery, but then that builds on itself to the depositions typically, where then you use the exhibits, you use the answers that you got in the written discovery to build to the depositions. That in turn provides a foundation for the more dispositive motions for summary judgment and the like. And all of this sort of builds on itself. I think one of my big takeaways more from civil litigation was just how much of a sort of bottom up constructed organism each case is. And certainly the complex cases very much are a lot going on, a lot of it building on itself. And having that understanding of the foundations and laying a solid foundation is so important to being successful down the road when it comes to, depositions, advanced motions, and things like that.
Do you think these high number of settlements encourages the courts to be more efficient or encourages attorneys to be kind of more incentivized to settle because it means an easier job for them a little bit?
Oh, I think certainly, and I think there are plaintiffs, attorneys out there whose entire business model is often predicated around a quick settlement. If you're running a shop or a firm and you operate on a largely contingency fee basis, you're going to, in some cases, want the case that comes in that you're able to make your case quickly and efficiently, perhaps with a little bit of initial discovery, but try to make that case effectively at the outset. If you can negotiate a favorable settlement early on, that's less time that you have to spend. That's more money that goes to your client. And that's, I think, a pretty good win from the contingency fee perspective. And this would be, I think, sort of one of your maybe lower damage type of a case where there has been a wrong. The plaintiff does need to have their injury restored. And the faster you can handle that, the better it is for your client. And I think that courts definitely rely on high rates of settlement. The loads of cases that are in courts, speaking largely from experience in Los Angeles Superior Court, for instance, or in Orange County, if every misdemeanor went to trial, it would paralyze the system, and many cases would probably be dismissed, procedurally or what have you. If every civil case went to trial, it would back up the system immensely. The judges would become incredibly overworked, and it would be likely a disaster. A lot of these systems run on the assumption that there's going to be a plea, that there's going to be a settlement. In many cases, that plea or that settlement, I think, is fairly negotiated and probably reaches a just result. In other cases, certainly criminal, and probably in a number of civil cases as well, a good number of civil cases, those resolutions might not be proper. It might be more of the procedure kind of forcing the result, even if that's not really justice.
Do you think that was a big reason for those bail reforms where they would let out non-violent offenders and I believe it was like petty larceny, anything under 1,000 that was stolen out like almost immediately?
So I think that, there have been various types of bail reform. Sometimes, policies by prosecutors to not call for bail in certain low-level offenses or certain designated offenses. Other more wide-ranging reforms, I think like in Illinois, for instance, have tried to do away with money bail to a large degree. And to the extent that these bail reforms are happening or are priorities, I do think that concerns over people being pressured into guilty pleas are a big motivator, and I think a valid motivator. A case is much more likely to plead out if the defendant is held in custody pre-trial. That adds so much pressure on the defendant to settle, Often you're looking at offers where, if it's, especially if it's a low level misdemeanor, you may be facing time served offers where essentially if you plead guilty, you can leave on probation, subject to conditions, sure, and paying a fine, yes, but you can get out of jail if you plead. And that's really appealing. You can fight, you can file a motion, you can go to trial, but you're going to have to stay in jail that whole time, and that stinks. And beyond that, it's difficult to defend a case when you're in jail. Meeting with your attorney, it's incredibly hard compared to being able to set up a meeting, go to their firm, or have them come to you outside of jail. It's many more administrative hoops to run through. It's difficult for the client. It's difficult for the attorney. Contacting witnesses, doing all that other stuff. If you're in jail, that is much, much harder to do. So all of these lead to a situation where cases are much more likely to plead out if the person is being held pending trial. And in some cases, it may plead out to a result that is not warranted, to charges maybe that aren't really supported, to a sentence that is higher than it really should be. And on occasion, there's going to be defendants who are innocent and who just want to get out. And even if they're innocent, they're going to do what they can to get out of jail. And I think a lot of that is part of the concern that motivates and continues to motivate bail reforms. It's certainly what motivates my scholarship on bail reforms and the like.
What is your scholarship on it specifically?
Yeah, sure. Relatively recent stuff. None of it's actually published yet, but all of it is accepted and up on SSRN. You can find it on my faculty webpage as well. The two big pieces I've written thus far, one of them I propose, they're sort of kind of quirkier or more targeted bail reforms. Like you have the big ones, sort of, eliminate cash bail, for example, or alter procedural rights so that there is a right to counsel. There is always counsel present, from the initial stage of setting bail. And I think those reforms are perfectly worth considering in their own right. My sort of additions have been to sort of maybe think a little outside the box and maybe think through what it would be like to do some things. So for instance, one of them is I argue that every bail determination, unless it's a release on your own recognizance where the person is let go, violate no new laws or whatever, unless it's that, the decision has to be justified in writing. And I think through, what that would entail. Judges would have to think through usually a list of factors that they're required to consider by statute, but generally don't when it's a less than 1 minute oral hearing with very limited documents. Judges would be required to think through, list out what the basis for holding the person is, put it in writing, deliberate through it. And it might be so inconvenient, it might be so unpleasant that it could just be easier to let people out on their own recognizance. And so we just might see more people let out and then able to mount a successful defense and potentially get a better result if that's what ends up happening. In a nutshell, that's what that piece is about. The other piece explores an absurdity, as I argue, when someone is held pre-trial because they are dangerous or deemed dangerous, but then they're given a time-served offer. And that leads to a situation where it's basically, if you plead guilty, out you go. But if you don't plead guilty, we're continuing to hold you because you're too dangerous to be let go. And that to me seems a little bit wild. If you take the guilty verdict, out on the street you go. You're safe enough for that, but you're too dangerous to be let go otherwise. And that to me strikes me as bizarre. I argue for mandatory rehearings in situations like that. Go into some detail, but that's in a nutshell what the second piece is about.
That's very interesting. That's almost like saying that that's like an oxymoron, almost like you're bad but not bad enough for us to keep you. If you say you plead guilty.
That's how I see it. And it is complicated. There are reasons to hold people on bail other than dangerousness. They might be a flight risk. You might not think they're going to return. You look at their record and they have this history perhaps of violating, return to court orders and things like that. So there may be reasons other than dangerousness to hold someone, which is why the argument in the piece is we need to have a rehearing. But there are absolutely cases where the decision is based on perceived dangerousness, and nevertheless, they are given time-served offers. And to me, that's something that should be allowed to continue. That person should be let out. And then once they are freed and, bail is lifted, then they should have the opportunity to decide whether to plead or whether to continue to defend their case. Some of them might plead. A good number of them might plead if they don't think they're going to win. Defending a case is a hassle and might get them nowhere. But I think more of them might actually go through with that defense and may well succeed or get a reduced sentence because they're able to genuinely defend themselves rather than sit in jail pending trial the whole time with that constant pressure to get out.
Do you think that's, excuse me, one of the reasons for that is that in the legal field we have too many definitions and terms and elements to an element of an element where everything is so convoluted. Sometimes the attorneys themselves don't know how to view this person, this case in this specific manner.
I got a lot of complex thoughts on that broad question. I think that I don't see it as I'm sure in some cases it's a problem, and there are some actual situations where and even in the bail situation, I could see it being a problem. On the one hand, I like detailed and explicit statutory schemes that say you need, as the judge, to consider these various factors in letting somebody out. And they list maybe, 10, sometimes more, sometimes like close to 20 in some of these jurisdictions. You have to consider all of these things. When it gets too lengthy, though, I think there's then a tendency to ignore stuff. A list of 7 things. Okay, maybe we can work through and think through all of those things. But now the list is up to 20. And it's just so big that I can ignore this one, I can ignore that one, because who's going to really be able to have the time in a bail hearing to consider all 20? And now once we've decided not to consider this one or that one, well, now we don't need to consider this one, or this one, or this one. An overly complicated scheme on paper may look great, but in practice may be more likely to lead to, violations or courts finding shortcuts around genuine consideration of all these factors. This, for instance, seems to be something that happens, at least in some jurisdictions in Texas, some litigation coming out of Harris County, really demonstrating, I think, that all of this is very automated with little consideration of the statutory factors. And so while I would love to see those factors recognized, and while I think it is a good thing for them to be there, I'm also aware that putting them on the books is not going to solve the problem. And a more complicated statutory scheme might just be something that prosecutors and courts and other actors in the system try to find ways to get around rather than genuinely engage with.
Having said that, do you think that overall, federally, maybe even with certain states, that certain rights are shrinking in the way they're being defended, used, or however you want to explain it?
I think so. I think part of that, what we've been talking about with bail is one example of that. And I wouldn't even necessarily call it shrinking, as it is maybe just, or maybe it is shrinking, but it's just been shrinking or not recognized for a very long time. I think, for example, there are rights, whether created by statute or constitution, that are genuinely given very short shrift. Many state constitutions, for example, have outright rights to bail. We don't really have a right to bail in the Eighth Amendment. We have a prohibition on excessive bail, yes, but a lot of states are much more explicit, saying that essentially all offenses, other than maybe these listed in these categories, are bailable and shall be bailable by sufficient security. There are explicit provisions that just do not mirror anything in the Eighth Amendment that appear in a lot of states, and yet people are held pre-trial, often on the basis of preset bails according to fee schedules with very little analysis by the courts or the other actors on whether people genuinely pose a danger to the public or are a flight risk. And those rights, existing on paper, are effectively useless. So bail rights, especially state constitutional bail rights, I think in many cases, I wouldn't even describe them as shrinking. I would describe them as effectively non-existent in many jurisdictions. There are other rights that I would add to that. Fourth Amendment rights, for example, over time, it's shrinking in a different way where you have, for instance, maybe Fourth Amendment protections that are established as part of the doctrine, rights against unreasonable searches and seizures, but then they shrink doctrinally as the court begins to create exceptions to the prohibitions, and so you can sort of see that shrinking happen over time. The doctrine itself is also shrinking as the court takes on fewer and fewer Fourth Amendment cases. This is a phenomenon that some folks have called out and documented. I think Oren Kerr especially has been beating the drum on this for some time about how we just don't have as much Fourth Amendment doctrine as we should. There's big questions, there's unresolved issues, but the doctrine is shrinking because the court's just not taking these cases. So that's another example of maybe a different kind of sort of rights shrinking phenomenon.
On the Fourth Amendment issue, do you think the courts are avoiding these cases because they don't want to answer these questions, or do you think that they don't think it's a legitimate issue that they need to answer, or none of those options?
I think it's a mix, but I think one, so Oren Kerr's theory, which I happen to buy into because I find it pretty compelling, is a little bit more specific. There is a rule called essentially the good faith exception. And there's a particular case. I'm terrible with case names. Law professor, it's great, but I'm pretty bad with case names. But I believe it is a case called Davis, where the court essentially what happened was there was a challenge to a search of a vehicle. While the challenge was pending, the Supreme Court decided a case that basically ruled that the way the search was done in that pending case was improper. This case then went up to the Supreme Court, and the court ruled that, well, it wasn't the law at the time that the search was improper. The officers had acted in good faith in searching the car. And so while there was a Fourth Amendment violation, we're not going to exclude the evidence. The exclusionary rule doesn't apply because it was a good faith action by police. And then think through what the implications of that are. If you come as a defendant to a case, you want to argue that a search was unlawful, and it's not within the four corners of existing doctrine. But you think that you might be able to convince the court that it was an unreasonable search. It's a new set of circumstances. You've seen the justices change. The best outcome for you under Davis is that you work your way up to the Supreme Court, you win, and your name becomes part of, my case book in my criminal procedure class. It gets remanded, and that evidence still comes in because the officers were acting in good faith. You lose, you go to prison. Congratulations, you've won at the Supreme Court. You're still in jail, you're still in prison because the evidence will still come in. That, I think, creates a disincentive against bringing these challenges or at least appealing these challenges, because where are they going to go? And I could see, I think I can't empirically back this up. I can't connect that change in the doctrine to sort of what's happening on the ground now. But, since Davis, there haven't been all that many criminal Fourth Amendment cases. A lot of the ones the court has taken have been 1983 civil rights civil suits. So the court is sometimes addressing these issues, but usually in the civil context, which I think supports the story that this lack of an incentive to bring challenges as criminal defendants is really hampering the development of the doc.
So, the good faith exception, would you say that's almost like a kind of like a jail get out of jail free card for these prosecutors or these officers? Like, hey, we didn't really follow the rules, but we were working under this idea of good faith that they probably don't even have a definition for per se. It's
I
just the
mean,
officer's opinion of good faith.
I don't like the phrase "get out of jail card, free card" because someone is going to jail because of this. But I think that's kind of right. Or at the very least, it's a way of avoiding the consequences of a Fourth Amendment violation. The way that our system works is that typically the consequences of a constitutional violation by police officers is that the evidence that is uncovered through that violative conduct is excluded. This is the exclusionary. That is the way that the court has decided to typically have as a remedy for Fourth Amendment violations and various other violations of criminal procedural protections. The court, especially the modern court, has really chipped away at that exclusionary rule on pretenses or on sort of the basis of assumptions that I think are dubious at best, but probably, frankly, genuinely false. Sometimes claiming, well, there are civil remedies that could happen, and that could be the way that officers might be deterred from misconduct. Number one, I think it's about more than just deterrence. I think it matters that the evidence before the court be obtained through lawful means, and that if we allow evidence obtained unlawfully, the court is essentially signing off on the violation. But even then, the deterrence rationale breaks down because 1983 suits, civil rights lawsuits, and certainly federal civil rights lawsuits are incredibly difficult to win, incredibly difficult to get damages on. And so when the court limits the exclusionary rule through the good faith exception, through various other exceptions, I think that it's doing so with under the promise that there is another thing that defendants could do to recover for their wrongs when that alternate mode really just doesn't exist.
The court's made some other, I guess you could say, major decisions in the last couple of years with abortion and gun rights. That was probably the two biggest topics we've ever talked about in con law. Wh- What are your thoughts on those? I mean, abortion is now, I believe, a state issue, no longer a federal issue. Do you think that's better, worse, back to the old way? Why can't we make a decision?
Yeah, when I taught con law for the first time ever, it was fall 2022, and we were coming off of a heck of a Supreme Court term. That was right after Dobbs. It was right after the court's decision in Bruin, a big Second Amendment case. And so there was a lot going on. On the abortion question in particular, I think that, you know, this is getting to sort of Dobbs versus Jackson Women's Health Organization, the big opinion where the court overruled Roe and Casey and concluded there is no federal constitutional right to abortion. The court did so through a methodological approach that I have criticized at length in various places of my scholarship. And so, to the extent that the decision sort of rests on that flawed methodology, I certainly have concerns with that. In terms of the rationale of returning it to the states, though, and democracy, that to me has never really sat well with me because the court makes these general proclamations about it's going back to the states, it's up to them. But they know what's going to happen when they return it to the states. During Dobbs, a lot of states had what were called trigger laws, laws on the books saying if Roe or Casey are ever overturned within 30 days or however many days, abortion is illegal, maybe with certain exceptions, but now abortion is illegal, these restrictions kick in. And the Supreme Court justices, as much as I criticize them, I don't think they're idiots. They knew these laws were out there. And so when they're claiming that we're returning it to the states and they can decide, they knew that the states had already decided. They knew what the consequences of that would be. And so casting it purely in terms of democracy and process, free of any substantive consequences, I think is at best a little bit disingenuous. So in terms of that justification for the opinion, it doesn't sit terribly well with me. All of that being said, it is now very much an issue of democracy, although it's also an issue of state constitutional law too. One thing we've seen since Dobbs are a lot of states enacting state constitutional protections explicitly protecting abortion, either absolutely or to some degree. And so while it has returned to the states, it's not maybe your typical, it's state legislatures working through this. A lot of the times, it's the people of the states coming together and putting these protections into their own constitutions.
If it was up to you, what would you do? Would you make it a state issue, federally, like, across the board? How would you approach that topic?
I think I would have favored keeping Roe and Casey in place. I think that we have gotten to a point where there is now a patchwork of restrictions and levels of protection, and I think that lack of uniformity is concerning. Personally, I am in favor of a right to abortion and a recognition of a right to abortion. And I find that states that impose very stringent restrictions in some cases on that right are doing harm and leading to unfortunate consequences. Whether it is a lack of an ability to exercise that right to abortion, or maybe getting more coverage and even more controversially, the ripple effects of that. People who come needing care for, let's say, a miscarriage or complications with the pregnancy, and doctors being overly cautious because the strict law on the books could be construed to apply not just to a typical abortion procedure, but to whatever procedure is necessary to remedy the miscarriage and to get that person out of danger. There have been several there have been several high-profile cases of women who have either sometimes died or sometimes become severely ill or injured because of the sort of overcautious reaction that healthcare providers have to these stringent restrictions. And that to me seems is a reality that I that does not sit well with me, that of which I do not approve. So for the sake of some uniformity, for the sake of some baseline protection, I would prefer there to be some federal protection. I understand it's not the world that we live in, and so it's not something that I argue, is recognized now. Dobbs says what it does. But personal opinion, that's probably my thought.
Speaking of a lack of uniformity, gun laws, I mean, those are becoming even more muddy. Another, I guess, issue to the states. Um, Bruin was something that were going back to the historical context or the historical approach, if I'm not mistaken. Can you explain what that means to even a law school student who doesn't get it?
No, sure thing. Very complicated, a lot going on, in several cases probably implicated. I will say at the outset, going back to the States, no, not really. This is very much the opposite of what we were talking about with Dobbs. The courts now, I think, have much more leeway to strike down restrictions on Second Amendment grounds, and we're seeing that in the wake of Bruen. In a nutshell, Bruen, the Second Amendment, was the state of affairs. So up until 2008, the Supreme Court had never recognized the Second Amendment as an individual right. It did so in a case of District of Columbia versus Heller, concluding that the Second Amendment protects an individual right to keep and bear arms, focusing around self-defense of the home, and not and remaining vague on how to go through determining whether there is a violation or not. In around 15-ish years between Heller and Bruen, the lower courts came together and developed a relatively uniform standard of testing whether there was a Second Amendment violation, typically asking whether the conduct at issue is protected by the Second Amendment in the first place, and if so, applying the appropriate level of scrutiny. Sometimes strict scrutiny if it was a substantial infringement on the right to keep and bear arms, which then would lead to laws often being overturned, but more often intermediate scrutiny, requiring that the government demonstrate an important interest and that the law at issue is rationally tailored to achieve that important interest. This went on for about 15 years before Bruen happened, and the Supreme Court sort of swept that entire lower court doctrine away, saying it's not about scrutiny, it's not about the government interest and tailoring. Instead, if conduct that is being restricted falls within the text of the Second Amendment, an inquiry that, at least in the Bruen court, considering the concealed carry of firearms, did in about a page, very easily and very briefly. If the conduct is protected under the text of the Second Amendment, then the burden is on the government to show a historical tradition of restrictions that are analogous to the one that they are defending in the present case. It's not clear what exactly that entails. If it's a state law, for instance, they have to go to the founding. Do we consider what was happening at the time of Reconstruction and the 14th Amendment? The timing of that is still very much up in the air. How many laws are enough to demonstrate a historical tradition? The Bruen court, for example, in one case it was considering, said 3 examples of restrictions on guns in sensitive places are enough for us to say that there is indeed a carve-out to Second Amendment protections in instances where states are restricting guns in sensitive places. But elsewhere in the opinion, they were like 3 colonial restrictions is hardly enough to demonstrate a historical tradition on the carrying of guns. The Bruen court itself doesn't give much guidance. In terms of rules, they say, look to the interest motivating the historical law and look to the similarity between that restriction and the present restriction. In Bruen, the court was incredibly strict and stringent in its analogizing, dismissing laws that were restricting certain instances of the carrying of guns, but not broadly restricting it. And you may have a follow-up question about this. In Rahimi, a later case that followed Bruen, the court was much more flexible in drawing analogies from history. There, the issue was, is it constitutional to prohibit those who are subject to a restraining order after a finding of individualized dangerousness to the protected party? Is it unconstitutional to restrict those people from having guns? Everyone watching the court, even people who think that the court is quite conservative, thought the court is not going to uphold that challenge, which somehow made its way out of the Fifth Circuit. And they didn't. In an 8-1 decision, the court said, oh yeah, that restriction is constitutional, kept it very narrow though, but were very much more sort of liberal in their analogizing to the past. They said, well, these examples and these examples together form enough of a tradition for us to conclude that this restriction here is okay. A very different type of analysis than the court did in Bruen. So where do things currently stand? Well, we have the Supreme Court doing historical tradition analysis in 2 very different ways, in 2 cases that are 2 years apart. And to me, I think it really remains up to whatever the court wants to do. If they don't like the law, they can do kind of what they did in Bruen, consider historical examples, but find some way to kick them out of the consideration. But if they like the restriction, they can do what they did in Rahimi. derive more principles of historical restrictions and traditions from examples that are presented by the parties, and from those principles conclude that the current restriction is analogous in a much more sort of holistic and permissive approach. The concern that remains for me is the court can kind of pick and choose how stringent it wants to be without really any explanation, leaving it up entirely to their opinion on just sort of how strict they want to be with the analysis, which will then ultimately decide the case.
Do you think they do that intentionally so they can kind of pick and choose how they want to apply the rule when the time comes? Or do you think it's more so, I guess, an originalist or historic or contextual perception of like it's only this and only that?
I think we'd be fooling ourselves if we said there wasn't any sort of strategy involved here. I think having that flexibility here, we're talking specifically within a single method. This is all sort of, I have called it a traditionalist approach to constitutional interpretation. And this entire discussion has been about how this approach can be manipulated in terms of levels of generality, what evidence we consider, and how heavily we weigh different pieces of evidence to reach whatever desired outcome we want using, let's say, the same body of evidence in this case or this case. I think that the flexibility of that method, but the fact that it uses historical evidence is advantageous to the court. They gain the legitimacy, sort of the legitimacy credit of we're looking to history and we're not looking to our own public opinions or trying to determine how dangerous guns are. We're not doing that difficult work of opinionated policymakers. We're doing our job as constrained considerers of the history. But I think they know that history, like precedent, can be presented and framed in a way to lean towards a certain outcome rather than another. It may narrow the universe of outcomes, but in the cases we care about, it's going to be manipulable enough. And all of this is just within one method. More broadly, the court can and does decide which method of interpretation to take, depending on the case before it. So we're talking about the Second Amendment this whole time, but if it's a question of usually First Amendment, let's say, that's much more often a question of doctrine. The court's usually not looking to history or tradition, but more is looking towards prior case law, rules that have been set out, and applying those rules and cases in varying degrees of, flexibility or analogizing. The court has chosen to apply that sort of common law method in the First Amendment space more generally, and this more traditionalist method in the Second Amendment space. And in some cases, the choice of method could be the decision maker. There's a lot of folks who I think would argue that Trump versus Anderson, the disqualification case where people raised a challenge to Trump's eligibility for president, saying he couldn't be eligible, he had committed insurrection, and under Section 3 of the 14th Amendment, he was disqualified. There were originalist scholars out there who were at least trying to make the case that as a matter of original interpretation, Trump was not qualified to be president. Got a lot of play at the time, went up to the court. Originalism played no role in the decision. They did a more structuralist type of reasoning, didn't really dig into the history at all, and that choice of method largely is what decided the case. I think the court knows this, it does this, and that flexibility allows it to get the results that it wants, whether those results are desirable as a matter of policy or maybe desirable in terms of the institutional legitimacy perception of the court. I think there's a lot of those factors in play, with the methods really taking a backseat to those deeper considerations.
Just so the audience knows what First Amendment is freedom of speech, and would you like to explain what an originalist is to them?
Oh yeah, getting ahead of myself, aren't I? First Amendment, freedom of speech, check. Originalist, what is an originalist? Oh my goodness, there's another podcast episode for you. There are variations on originalism. At base, there's one, I think, very, very approachable and very clear and thorough scholar out there. There are several of them, but one who I have in mind is Professor Lawrence Solum. His sort of take on originalism is that there's two main elements to the family of theories that is originalism. Element number one is the idea that the meaning of the Constitution is fixed at the time of its enactment. And element number two is the idea that judges should be bound or constrained by that fixed meaning. This is the fixation thesis and the constraint principle. From there, you have a lot of varieties of originalism. Some people say we should look to the original intentions of the framers and the drafters. Others say we should look to the original methods they employed to interpret the Constitution. The most popular or sort of mainstream example is called original public meaning originalism. That being the Constitution's provisions mean today what they would have meant to a member of the general public at the time of the founding. What would a reasonably well-educated member of the public have taken the Second Amendment to mean? That is the meaning we should be using today as we think through Second Amendment disputes.
You've written a couple articles about originalism. What's your opinion on it?
Not a big fan, and anyone who takes a glance at my scholarship is probably going to find that out. I generally, and I have a number of qualms with originalism. I think my two big ones are largely from implementation. I think originalism is fundamentally difficult and often impossible to implement thoroughly and honestly. I think that on one level, judges and attorneys are not historians, and originalism, at least on paper, is demanding them to make conclusions of historical meaning. The endeavor to do that is, I think, much more complicated than many originalists are willing to let on. There's a lot of relevant context that feeds into what historical legal meaning was, what historical linguistic meaning was, and a lot of originalists say, oh, it's just a legal question, we can focus in on that. I think it's generally going to be more complicated than that, and frankly, you're not going to know how complicated it really is because you don't lack the expertise to know how difficult the question is in the first place. I think a lot of judges and lawyers, for instance, are going to fall into the trap of trying to do it and getting it wrong. And I think they are necessarily going to do that because they're not experts, they have time limits, they're dealing with the submissions of parties that are trying to win the case for their clients rather than to do a thoroughgoing review of the historical evidence. And the institution of law and the adversarial system, I think, is just fundamentally inconsistent with the genuine historical fact-finding that we would need to do to get originalism right. So that's one of my big qualms, and I've written several pieces exploring that theme. On another level, I find originalism to just not be terribly transparent. I think that it's one of many methods that are actually employed by the courts. But the court and a number of originalists, I think, assert that this is the way it has to be. This is the method of interpretation we need to apply. In fact, they can and do choose between these methods, but when they're doing originalism, there's much more rhetoric of kind of inevitability. They don't recognize how they do have a choice and explaining their choice of method. I don't think originalism may always be the wrong way to do it. What I do think is happening, and what does concern me, is that they do originalism without explaining or justifying why it is the proper approach. And without that justification or explanation, that leads to the strategic use or non-use of originalism, leaving the court to sort of choose the method without explanation, and in doing so often choose the desired result. That's why I am more of sort of a pluralist for interpretation. I don't believe in one method. I think the way the court does things and the way it should do things would be to use multiple tools in the toolbox. But in doing so, they should explain how and why they are making the decision to choose or implement those various tools. I think this happens at the state level. I'm not the only one who's thought that. There are several scholars whose work I deeply admire who argue for this too. Philip Bobbitt, Richard Fallon, and Richard Ray, in particular, I think some of the three most interesting scholars on pluralist theories, from whom I've drawn a lot of inspiration from in my own work. And I like to apply sort of those ideas and develop them at the federal level, but especially at the state level. I think there's so many examples of this actually happening there that we at the federal level could learn a bit.
I want to circle back to the First Amendment real quick. How much do you think social media has changed how lawyers, scholars, judges, everyone looks at the First Amendment now?
I think that social media and the media ecosystem that it's created has led to a fundamentally different landscape and environment upon which we try to litigate and justify the First Amendment. So earlier, you had this, so for instance, you have this metaphor that underlies at least one big justification for the First Amendment, and that's this marketplace of ideas. The idea that if we sort of open up expression, allow people to put their views out there, they will bump up against one another and sort of the true ideas will rise to the top. Very crudely put, but that's sort of, in a nutshell, this marketplace of ideas notion. Social media, I think, has led to sort of, much more polarization. It's led to the development of online communities and echo chambers. And I think it's led, and as well as to the proliferation of misinformation, to the point where expecting that debate to go in a sort of reasoned manner is less and less of a plausible hope. And so to the extent that theories of the First Amendment as justification and rest on that, I think that the landscape today is just much more different and at least should require us to ask questions about what it is the First Amendment is doing, why we have it, and how we should maybe interpret it or apply it with that in mind. Beyond that, I think social media has just also demonstrated why, originalism and historical interpretations have their limits. I think that, we can maybe analogize in gun cases to, handguns. They're kind of like these weapons that existed at the founding or something like that. But when we're dealing with a First Amendment case where a high schooler who didn't make the cheerleading squad while off campus on high school puts on Snapchat various profane words about the cheerleading squad and the decision to reject her from the team or to reject her application. And whether disciplining her for that Snapchat expression is a violation of her free expression rights. It just shows that technology has changed or developed to such a point that we need to sometimes think through these things anew and just develop new doctrine and try to do our best, realizing that history and even the text aren't really going to be of much help to us in those situations. So how has technology and social media changed things? I think it's really made us hopefully starkly realize just how much good judging and thinking through the doctrine is needed when judges might want to try to sort of use methodology as an excuse to make these things a little bit more automatic or to seem predetermined.
So would you say the court is almost behind into the time to keep up with the modern day, I guess, world we live in?
I think probably yes. The doctrine is notoriously slow to develop. If you're doing a common law approach to things, you have a case that comes out and then you have another case that you analogize to the previous one. You do it as the disputes arise, as it gets to the courts, and as it works its way through appeals. That all takes time. That all requires kind of the right cases to get to the right courts. And that's a slow and inefficient process. I think there are benefits to it. It organically does help the law sort of develop, adjust to new circumstances. And I think there is, if we're doing, a good job of this and really genuinely letting many courts work through these things, it does allow the law to adapt to these circumstances. But I think it's generally going to be a slow adaptation. And the other thing is, the sort of strong and absolute freedom that the First Amendment and some of its, supporters and advocates argue that it provides, it worries me that view of sort of First Amendment absolutism or even strong First Amendment protections. It does concern me when we think about applying those strong protections in worlds where certain speakers or certain entities that govern or host the discourse then have so much power already. And to constitutionalize that power and to free it from any sort of regulation, that worries me that the constitutional law could stymie well thought through regulation. I don't think it's impossible to regulate this stuff. I think there probably are difficult choices to be made, but ways to sort of make things at least better. I worry that if we take too much of a constitutional approach, that might be too much of a blunt object in either direction. And that could lead to, I think, a doctrine that just doesn't fit with the complexities of reality.
So you're more so a proponent of letting it organically weed itself out and how to find its way.
I suppose I am. I guess I haven't really thought through kind of like, this is the method and this is my theory of the First Amendment. I've written about it a lot, and I have concerns on sort of a more case by case level. I think a more sort of, yeah, common law, though, doctrinal development is, for me, I guess, an approach that I generally like. I also, though, have just concerns about absolutism, sort of rights generally, but I think we see this a little bit more starkly with First Amendment cases. This idea that the First Amendment sort of trumps anything else that might stand up against it. I think that that view of sort of, as Jamal Green would put it, rights as trumps is a dangerous landscape, or a dangerous sort of framing for these disputes. We should recognize that there are arguments on both sides, and there may well be some balancing of interests to do. If we're too stark in how we approach things, I think we lose sight of those interests. It becomes all or nothing, and we end up with a doctrine that just, as I sort of suggested earlier, doesn't really fit to what our needs are as a complicated society.
As a complicated society, we have AI now. AI making everything more complicated than it should. How do you see the legal world at- attacking, adjusting to the world of AI, from ChatGPT having legal models and LexisNexis having their own AI? How should lawyers and future lawyers see that? Be scared, worried?
I think it's something we should at the very least be aware of. Um, I generally I do I am critical of AI. Personally, I am not a fan of a lot of generative AI, as in particular as a professor. I find that a lot of hard work that AI allows us to circumvent, that hard work is rewarding and important in many ways. A student who's taking a legal writing class is going to write, for instance, a motion for summary judgment or something like that from scratch. That's not how the real world works. You usually are using a template, you're modifying something, but there's a reason we ask them to do it in such an unrealistic way. It's so they can learn the basics, think through things, get a handle on the complexity, build judgment about what good writing looks like, and then in the future be able to take those other shortcuts, potentially including generative AI. I'm much more of a plagiarism fan myself, but you know what? Go and use generative AI if you'd like. I would much rather copy from one of my prior motions that I know is good. But hey, go have a computer think of a bunch of hallucinated cases and see how that works in front of a court. Sorry. Little opinionated. It'll get better, so they tell us. I have my doubts. But that requires technological expertise well beyond my capacity. But in the end, is there something we have to fear from it? As lawyers, I don't. As lawyers, I would like to say no. And the standard line by people who sort of urge this cooperative and accepting view of AI is that AI will help us. It will be a useful tool that'll make us better lawyers. The judgment and the wisdom that we bring to cases, the subtle knowledge and the ability to work with people and make judgment calls, that's a human function that we will maintain, and we will be much more effective in that through AI. I think on paper that's possible. Maybe that would be a nice world to live in. Do I think that's going to happen? I have my doubts, and here's why. I think that law firms and other legal employers care about efficiency a lot, and they are going to see AI and quicker methods as shortcuts to efficiency. They may think, my goodness, we don't need first-year associates to do all of this grunt work of discovery, drafting, document review, and things like that, so let's just do away with the first-year associates. Let's hire a bunch of mid-year associates. And you know what? That might be okay. But all of a sudden, you're out of first-year associates because this single-minded quest for efficiency has cut off the inputs to the law firms. And now you're finding yourself with no one from inside of your firm because you've let ChatGPT and other things do all the basic work for you. You're finding yourself without a next generation. That's my sort of more apocalyptic view of where the practice of law might go. I could see lawyers coexisting with ChatGPT, with generative AI. I could see educational institutions maybe coexisting with these technologies, although I think that their role should be much more limited, with a recognition that we need to teach people to become good users before they begin using the technology. I could see those all as possibilities, but the quest for efficiency and cost saving that governs law firms' bottom lines, that educational administrators are constantly looking to, those are high priorities. And I worry that they are going to win out over the complexities of what we're actually trying to do as educators, to teach people to think through things and to become good users of the technology before actually using the technology. As lawyers, people who get to know the building blocks of that case and how they build onto one another. As I mentioned earlier at the beginning of our conversation, the written discovery, formulaic, unpleasant, man, it was such a headache, and so much discovery work I did as a junior associate and as I did as an associate throughout my career. But that grind did teach me what the case was about. It helped me down the road draft more efficient motions for summary judgment, and as we were preparing for trial, it helped me know what the landscape of the case looked like and where the smoking guns or the landmines were that we needed to avoid or that we needed to push our opponents onto. And I worry that if we automate a lot of that, make it more efficient, it might cost less, but the other cost is that knowledge of the case and a thorough understanding is lost. That judgment becomes all the more difficult. And in becoming more efficient, you lose the benefits of inefficiency.
At that cost, do you take the apocalyptic view of AI will replace lawyers potentially, and only trial attorneys will be the ones of value?
I don't think I would go that far. I think attorneys and the organizations that continue to perpetuate their existence are too clever for that to happen. We still have the bar exam, and if those robots don't pass the bar, well, we're not going to allow any of their filings into the court. There are mechanisms in place that might bar them. In the end, I don't think it will happen. I think in part because I'm doubtful of the predictions that this technology will continue to exponentially increase and become incredibly better. I think that there are predictions like that being made, and I suspect, albeit not an expert, but I suspect that they are overly optimistic. I think that the cost structures for a lot of these big AI companies are questionable at best. How are they making money? Will they continue to make money and to continue to improve their product? I think there are substantial questions about that. And do people want a lawyer in their corner or a machine in their corner? I would hope that people out there would still want a person there that they can talk with, that they can trust, that they can have these conversations with, and that they know cares about them. ChatGPT, it's so much rhetoric of respect and care, right? Oh, I'm so sorry I made up that case. My bad. Oh, that writing that you did, this sample, it looks so great. Here are a few humble suggestions for how to improve it. It's so nice. It's so deferential, and it's hollow. It means nothing to me. And a relationship with a person, having an attorney there, having a person you can trust and send out there on your behalf, that's meaningful to me as a client. As a court, that's meaningful for me. I'm going to listen to an argument that a person is making to me more than I would listen to some robot-issued submission. And I think the advantages of that and the credibility that we instinctively feel through interacting with other humans, my maybe optimistic hope is that that's what's going to save us from my apocalyptic visions.
What's a misconception you think Hollywood has created about the legal field and or I should say, how about this? What's a misconception Hollywood has created about individual rights in the Constitution?
I think that, and I don't know if I would, put the blame or the responsibility on Hollywood, as I would maybe sort of more Hollywood and popular culture more generally.
Sure.
I do think that there is a tendency to over-constitutionalize things. I think that the idea of arguing above all that I have a right to this has become such a pervasive and seemingly important rhetorical tool that it crowds out other alternatives that might be better. I mentioned earlier, for example, Jamal Green and his writing on sort of rights as trumps. He has a wonderful book, How Rights Went Wrong. I recommend it to everyone. Sort of this idea of kind of rights absolutism that has grown up over the years and is crowding out sort of genuine questions of proportionality and balancing that we should really be considering. I think popular culture and sort of an over focus on the Constitution has played a role in getting us to that. arguing above all else that I have a right to this and prioritizing that rather than thinking through alternative ways of advocating our positions. And I think just generally a little bit too much reverence for the Constitution. It's okay for me to say this because we're 2 days past Constitution Day. I think that there is just too much focus and attention to the Constitution. Oh my gosh, society is going in this direction. What did Trump do? Holy crud. What can the Constitution do to get us out of this? Stop it. The Constitution isn't going to help you in all of these cases. Maybe it can be of some help. I think the arguments are certainly worth making, but they need to be made alongside other things. And I think the Constitution has a tendency to monopolize the academic, legal, and political discourse in a way that I think ultimately gives us a fair amount of tunnel vision towards our social problems. Frankly, I think the same is true of law in a lot of places as well. There's this social problem. What can law do to fix it? Maybe some stuff, but there's going to be tougher things we need to do, different solutions we need to pursue than just passing another law. So a roundabout way of saying that I think Hollywood and maybe popular media more generally has contributed to that through its sort of prioritization of the Constitution and over-veneration of the Constitution in some cases. I think the Constitution is massively important. My career is built around teaching it and its doctrine, and I think it has a role to play. I think it's dangerous to conclude that it is the only game in town, and I say that also as a state constitutional scholar. We have the U.S. Constitution, but don't sleep on the states, at the very least. There's a lot of constitutions to go around, and I think all of them are worth considering, as well as the law more broadly, and as well as social and political considerations beyond law and constitutionalism.
Piggyback on for that, what Supreme Court case do you think, if you could, you'd overturn it because they got it wrong?
That's a question I haven't thought about. And man, I mean, like, there's some that I think are wrong, but like, would this be the battle I would fight with my one little magic, card to overturn a decision? I'm not so sure. Bruen, for example, I think was poorly reasoned, has created a new absolutism around the Second Amendment, and has all but nullified any consideration of dangerousness and public harm of firearms. I think those considerations are important and should be part of the discussion. And I think Bruen has constitutionalized firearm regulation and tied it to history in a way that I think is going to have long-lasting, dangerous consequences. So I guess because I'm teaching constitutional law and have been prepping Bruen for teaching next week, it's on the mind, and it's there. Now, of course, are there other opinions that have occurred in the past that have had much more far-reaching and terrible implications? Yeah, probably. Probably if I thought through other aspects of constitutional law and doctrine that I'm not as much of an expert in, I would be able to give you something. For instance, I think, concluding in whatever the heck the name of the opinion is, again, I know the law, but I'm terrible with opinion names. Concluding that partisan gerrymandering is a political question, that seems silly to me. That might have substantial implications for democracy and policy making that have had ripple effects that we can't even comprehend given their complexity. Perhaps overturning that would lead things in a better direction. Although that's so complicated, I'm not sure if I could say. So if I'm going to answer your question, because I know about it, because I'm teaching about it and it's on the mind, let's say Bruen, but I'm largely answering it because it's on the mind. I don't think I know the right answer to that question.
For all the people in law school and attorneys aspiring out there, do you have any regrets becoming a lawyer?
No, I don't think so. I did for a while. I worked at some firms. I worked in some environments that I really didn't like, and there were absolutely days that I questioned what the heck I'd done. Was this all a horrible mistake? Maybe I should go on and, I don't know, fake my death, get rid of my student loans that way, and, go raise sheep somewhere on a hillside. Certainly there were days that I thought through that. But I found that I was able to, get past that, in part because no terrible job is forever. I found that I could move. I ended up at a firm that I really enjoyed, where I really respected the people I worked with and where I learned a ton. I'd still be at that firm, Glazer Weil in Los Angeles. I would still be there today if I hadn't gone into academia. But law opened the door for me to eventually go into the direction of legal academia, and what I'm doing now, this is what I love. I love to write. I love to think through rabbit holes. I love to teach people. I love to see people figure it out and get to become lawyers. I like to help people through that door to get them to the power and the responsibility of becoming lawyers. It's such an awesome responsibility to teach students and to shepherd them through to become attorneys and to see the incredible things that they do. That's crazy. I love it. And along the way, I apparently get like tenure and promotion decisions made because I can do what my hobby is, which is just to write law review articles. I just genuinely like it. I've admitted this to the dean. They know. They know that I don't do it because I want to advance professionally. They know that I do it because I simply do it for fun. It's wild to me that I'm doing a job where what I do for fun is what I have to do. And I think if anyone can get to that in any way, that's the jackpot. And I've gotten there. So right now, I love what I'm doing so much. I have no regrets. Could I have gotten here in a different way? Yeah, probably. But man, so much of the struggle and so much of the hassle and the stress that I've gone through in my time as a lawyer and as a law student have, I think, made me the person I am today. I'm not sure if I would even change those things. I think that the struggle and the success has all sort of made me who I am and contributed to who I am. And all of that was made possible by going to law school and becoming a lawyer. I think that, there are definitely downsides. It's not the right path for everyone, and it will sure as hell be difficult some days more than others. But if you move yourself in that right direction, and if you sort of put in the time, not just to succeed at the job, but to put yourself into the right job, I think you can get to a place where you'll be in a situation where you don't have any regrets either, or your regrets are at least minimal.
I was going to ask you to end on a positive note about your career path, but I don't think there's any way to top how the way you just ended it. So,
Yeah, life advice for everyone: become a law professor. Best job in the world.
and on that note, thank you for being with us today.
Thank you so much for having me. It's been great, and look forward to talking to you again sometime.